employees for the first time in India in the towns of Bombay and Ahmedabad after the commencement of the First World War, when, as a result of inflationary trends,
I say here. So what was our problem?
Yes, please.
Your Lordship has that 2007 7 SCC 472 Union of India versus Arjun Jyoti Kundu.
Yes.
Now here, please go to paragraph 16.
Yes.
We had recently held in K.S. Krishnaswamy, 209.
Yes.
We had recently held in K.S. Krishnaswamy that the recommendations of pay commissions are subject to acceptance or rejection. Speaking for the bench, one of us, Justice Sema, stated, "It is well settled principle of law that recommendation of pay commission are subject to acceptance/rejection with modification of the appropriate government. So unless the government has accepted the recommendation to merge the cadres, the court cannot proceed on the basis of recommendation alone or to direct the government to accept the recommendation. In this context, we have to take note of the decisions of this court in State of West Bengal versus Dev Kumar Mukherjee that the recommendation on pay scales are not open to judicial review, and the one in State of UP versus Ministerial Karmachari Sangh to the effect that the evaluation of typists for the purposes of pay scales must be left to the expert body. The role of the pay commission and that of the court has been dealt with in the decision of this court in Saurabh Chowdhury and MP Rural Agricultural Extension Officers Association. In the latter decision, it was held that by this court that pay commissions are constituted for evaluating duties and functions of the employees and the nature thereof vis-a-vis the educational qualifications therefore. Although the pay commission is an expert body, the state in its wisdom and in furtherance of its valid policy may or may not accept its recommendations. So the pay commission recommendations are not binding as far as the state government is concerned. It may accept them, it may in certain situations accept them partially, and then in others reject the app. Now please have a look at four sets of decisions which we want to place with regard to fiscal policy issues. The Lordship goes to the index. Serial numbers 2, 3, 4, and 5.
Yes.
The Lordships have that. So I'll just place, my Lords, para 21 of Bengal Chemical, page 49. Is where it begins. And if your Lordship is pleased to go to page 56. In Kamani Metals and Alloys versus Workmen, it has been noted that 100% neutralization is not advisable as it will lead to inflation, and therefore DNS allowance is often a little less than 100% neutralization. The following principles broadly emerge from the above decisions. Full neutralization is not normally given except to very lowest class of employees. The purpose of DNS allowance being to neutralize a portion of the increase in the cost of living. It should ordinarily be on a sliding scale and provide for an increase on the rise of cost of living and decrease on a fall in the cost of living. The basis of fixation of wages and DNS allowance is industry cum region. Employees getting the same wages should get the same DNS allowance irrespective of whether they are working as clerks or members of subordinate staff or factory workmen. The additional financial burden, which is a revision of the wage structure or DNS allowance, would impose upon an employer and his ability to bear such burden are very material and relevant factors to be taken into account. Having due regard to the above principles, we are satisfied in the instant case that the tribunal has made substantially a correct approach in considering the claim for revision of fairness allowance. Now, please have a look at the second decision, which is State of Haryana, page 65 at 71.
Yes, please.
The court in the case of Secretary Finance Department versus WB Registration Services Service Association, dealing with the question of equation of posts and equation of salaries of government employees, made the following observation. We do not consider it necessary to traverse the case law on which reliance has been placed by counsel for the appellants, as it is well settled that equation of posts and determination of pay scales is the primary function of the executive and not the judiciary, and therefore ordinarily courts will not enter upon the task of job evaluation, which is generally left to expert bodies like the Pay Commission, etc. But that is not to say that the court has no jurisdiction and the aggrieved employees have no remedy if they are unjustly treated by arbitrary state action or inaction. Courts must, however, realize that job evaluation is both a difficult and time-consuming task, and even expert bodies having the assistance of staff and requisite expertise are found difficult to undertake, sometimes on account of want of relevant data and scales for evaluating performances of different groups of employees. This would call for a constant study of external comparisons and internal relativities on account of changing nature of job requirements. The factors which have to be kept in mind for job evaluation may include the work program, the nature of contribution, the extent of responsibility, the extent of nature of freedoms, the extent of power vested in him, the extent of his dependence on superiors, the need to coordinate with other departments. We have referred to the history of service and the effort of various bodies to reduce the total number of pay scales to a reasonable number. Such reduction is in the number of pay scales has to be achieved by resorting to broad banding of posts by placing different posts having comparable job charts in a common scale. Substantial reduction in the number of pay scales must inevitably lead to the clubbing of posts and grades which were earlier different and unequal. While doing so, care must be taken to ensure that such rationalization of pay structures does not throw up anomalies. Ordinarily, a pay structure is evolved keeping in mind several factors: method of recruitment, level at which the recruitment is made, the hierarchy of service, minimum educational technical qualifications, avenues of promotion, the nature of duties and responsibilities, the horizontal and vertical relativities, public hearings, satisfaction level, employer's capacity to pay. We have referred to these matters in some detail only to emphasize that several factors have to be kept in view while evolving the pay structure, and horizontal and vertical relativities have to be carefully balanced, keeping in mind the hierarchical arrangements, avenues of promotion. Such a carefully evolved pay structure ought not to be ordinarily disturbed, as it may upset the balance and cause avoidable ripples in other cadres as well. It is presumably for this reason that the Judicial Secretary, who has strongly recommended substantial hike in the salary of sub-registrars to the Second State Pay Commission, found it difficult to concede the demand made by the Registration Service before him in his capacity as the chairman of the State Pay Commission. There can therefore be no doubt that the equation of posts and equation of salaries is a complex matter which is best left to an expert body, unless there is cogent material on record to come to a firm conclusion that a grave error has crept in and fixing the pay scale for a given post and court's interference is absolutely necessary to undo the injustice. It has to be kept in mind that a claim for equal pay for equal work is not a fundamental right vested in the employee, though it is a constitutional goal to be achieved by the government. Fixation of pay and determination of parity in duties and responsibilities is a complex matter which is for the executive to discharge. While taking a decision in the matter, several relevant factors come, some of which have been noted by this court in decided cases, are to be considered, keeping in view the prevailing financial position and capacity of the state government to bear the additional liability of a revised scale of pay. It's also to be kept in mind that the priority given to different types of posts under the prevailing policies of the state government is also a relevant factor for consideration of the state government. In the context of a complex nature of the issues involved, the far-reaching consequences of the decision in the matter and its impact on the administration of the state government, courts have taken the view that ordinarily courts should not try and delve deep into administrative decisions pertaining to pay fixation and pay parity. This is not to say that the matter is not justiciable or that the courts cannot entertain any proceeding against the administrative decisions taken by government. The court should approach such matters with restraint and interfere only when they are satisfied that the decision of the government is patently irrational, unjust, and prejudicial to a section of employees, and the government, while taking the decision, has ignored factors which are material and relevant for a decision in the matter. Even in a case where the court holds that the orders passed by the government to be unsustainable, then ordinarily a direction should be given to the state government or the authority taking the decision to reconsider the matter and pass a proper order. The court should avoid giving a declaration granting a particular scale of pay and compelling the government to implement the same. As noted earlier, in the present case, the High Court has not even made an attempt to compare the nature and duties and responsibilities of two sections of employees, one in the State Secretariat and the other Central Secretariat. It has also ignored the basic principle that there are certain rules, regulations, and executive instructions issued by the employees which govern the administration of the cadre. Then please, if your lordships are pleased to go to Punjab State Cooperative Milk Producers Federation,
Yes.
which your lordship will find at page 74, at page 97.
Yes.
Foot of the page.
Yes.
In KT Veerappa, the court upheld the principle that fixation of pay and parity in duties is the function of the executive, and financial capacity of the government is also a relevant factor to be considered, though on facts, it was held that the employees of the university were entitled to a revision of pay at par with employees of the state. It was held as under. He next contended that the fixation of pay and parity in duties, the function of the executive and financial capacity of the government, and priority given to different types of posts under the prevailing policies of the government are also relevant factors. In support of the contentions, he has placed reliance on so and so. However, it is also equally well settled that the court should interfere with administrative decisions pertaining to pay fixation and pay parity when they find such decisions to be unreasonable, unjust, and prejudicial to a section of employees and taken in ignorance of material and relevant factors. In the present case, it is contended that the Federation is a statutory cooperative society. The state government communicated on 1st March 1990 and 9th July 1993 the pay scales as applicable to the Punjab government employees is not to be adopted by the public sector undertakings without taking into consideration the financial health of other statutory bodies and corporations. The Federation has thus taken a conscious and concerted decision to not follow the report of the Anomaly Committee of the state government to grant revised pay scale from 1st January 1986 in view of the precarious financial condition. Moreover, financial assistance had to be availed by the Federation from the state government as well as the National Dairy Development Board. Then please have a look at, then after that, Tata Cellular, etc.
Yes.
Please go directly to para 49, which is one of the concerns which we have also taken up. Namely,
of the Federation was in financial difficulties.
no, not difficulty in the sense it's a question of fiscal outlay for our part. So it has huge ramifications, Manoj. And we have therefore applied our mind and had regard to all these particular factors. So, Manoj, that's one set of decisions. Now, if your lordship could go to another topic, which I just Mahatma Gandhi mission. Yes. 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 Manoj, please see the decision at serial number 8. Mahatma Gandhi mission versus Bharatiya Kamgar Sena
That is about
begins at page
central
148.
government and state government DA did not be similar.
Yes. At 177, paragraph 62.
Yes.
The fact that the Government of India accepted the recommendations of the 6th Pay Commission, for that matter, any pay commission, does not either oblige the states to follow the pattern of the revised pay structure adopted by the Government of India or create any right in favor of employees of the state or other bodies falling within the legislative authority of the state. The Government of India has no authority either under the Constitution or under any law to compel the states or instrumentalities to adopt the pay structure applicable to employees of the Government of India. I think this is a foundational principle. And in this regard, as Mr. Sibal had indicated,
The moment you bring in Mr. Sibal, we'll ask him to enforce our order.
no, we had actually done some.
Otherwise he is a stop for our
Down to whatever you're not.
No, but we had said that we were only expecting that order to be implemented. Partly, of course, that was subject to the outcome of the petition.
There is a,
You may do that, Mr. Sibal. Please ask your client.
there is a constitutional issue here.
No, what we are saying.
So that is also a constitutional issue.
No,
These
the
are
point is,
The
there are 13 states and
implementation of the interim order is a constitutional issue.
25%
of what, Manoj?
of
There is no
area.
calculation.
All.
There is no calculation.
So you have to do the calculation.
Well, how can I do it? I have to devise a policy, then I have to devise a framework. That's what the correction.
You may fix any amount and give it. You may say this is lump sum amount, but give it.
That means
This subject to the outcome. See, they are not running away.
we are also not running away.
You are, for them, they have to be fed.
No, I am not disputing that.
No.
That's not.
See, it's a question of.
I'm not.
So they've served you.
What's
They are
that?
your people.
Speak.
They've served you. They
No,
are your people. So give something.
There is no dispute on that.
Please do that. What we are saying. You may give any amount. You may give X amount, but give it. That's what we are saying. Please do that. Please persuade your clients to do that. And this is all subject to the outcome. Yes. Yes, Mr.
So, Manoj, I have also just, if you see my index of authorities,
Yes.
I'm not reading it because it's already quoted portion is read.
Yes.
But you recall that this Kamani Metals and Alloys at
Yes.
serial number 12, AIR 67, Supreme Court 1175. I read that quoted judgment from
Correct.
Bengal Chemicals, correct? So, which said that 100% neutralization of inflation may not be advisable in some circumstances, but if somebody is doing it, I don't have it, but it's another government.
Yes.
Now, as a point of information, the other judgment which we have placed on the same topic, your Lordship may just know, is Tamil Nadu. Yes, Tamil Nadu Electricity Board, which is at serial number 10.
This is also to the similar effect.
Yes,
Similar effect.
rates may differ. So, would your Lords, may I just take your Lordships to it? It's at page 189. And you may go directly to page 197.
Yes.
Lordships are para 22.
The main source of finance.
The main source of finance for an electricity board is the state government. The board is run by the state government. Unless the funds are provided by the state government, the electricity board would not have sufficient funds of its own to pay the wages and the revised DNS allowance to its employees. Considering the financial difficulties which the state government was facing, the revision of DNS allowance from the above said rates at the above said rate cannot be said to be arbitrary or without any reason. While considering the grievance of wage structure or DNS allowance, the importance of considering the financial implications while providing benefits to employees has been noted by the Supreme Court in a number of judgments. The Supreme Court in Workman versus Gujarat Electricity Board, while dismissing the appeal preferred by Workman, has confirmed the view that the tribunal which rejected the demand of the employees of the board for DNS allowance, that it should be fixed with the scale prescribed by the Ahmedabad Mill Owners Association, on the ground that the board does not have the capacity to meet the additional expenditure that would have to be incurred if such demands are exceeded. The Supreme Court in Bengal Chemical has laid down that 100%, and Kamani has laid down that 100% neutralization is not advisable, as it will lead to inflation, and therefore DNS allowance is often a little less than 100% neutralization. Explaining the purpose of the DNS allowance, and that should depend upon the ability of the employer to bear such burden. The Supreme Court held in Bengal Chemicals, full neutralization is not normally given except to the very lowest scale. The purpose of DNS allowance being to neutralize a portion of the increase. This is Manoj, which I had quoted and read.
Yes, correct.
And that additional financial burden also. So Manoj, this is a consistent principle which is to be followed. Now, the only point which I wanted to make was that as far as we have been able to ascertain, apart from West Bengal, the states of Kerala, Chhattisgarh, Himachal Pradesh, Karnataka, Maharashtra, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Telangana, and Tripura, which is a total of 13 out of the 27 states as well, we have been able to ascertain, do not follow the rates of DA declared by the central government. So they have their own, we all have our, yeah. So it's a distinct scheme depending on our facts and circumstances. But I'm very grateful, but may I just commit, we sort of divided our...
Certainly.
So if we could just have some supplementary...
7 minutes, not too much.
Yes. In fact, Mr. Devana actually covered everything.
That's right. I'm not going to touch on any of the things that he has said.
Yes.
I'm just apropos what fell from your lordship.
Yes.
Now, if you look at, as I was indicated earlier, you look at the 7th schedule, there are 2 entries which are very important.
Yes.
One is for this, entry 41, state public services. So, mothers, when a finance bill is presented for us in the legislature, and
Yes.
appropriation is done with respect to the expenditure, with respect to salaries and all components of salary. Right? Without that, no payment can be made.
Yes.
So whether it is DNS allowance along with salary, that has to be part of the appropriation bill. Outside of that, no payment can be made.
Correct.
Then if you look at entry 43, is public debt.
Yes.
Public debt of the state, mothers, is an important factor in deciding how much money is to be disbursed.
Please.
And we have the FRBM, the Fiscal Responsibility Act, in terms of which my deficit is fixed. Mothers. If I go beyond that, mothers, then consequences follow. Right, mothers? Now, public debt is exclusively in the domain of the state.
Yes.
And state public services, including all salaries, DNS allowance, all aspects, exclusively in the domain of the state.
Yes.
So the problem that arises is when the consumer price index is hoisted onto the state, mothers. If supposing there was an act, well, let's forget this, All India price, consumer price index. Supposing there was an act of parliament, it would not pass muster, saying you give this DNS allowance. It would not pass muster. So no tribunal, no authority can give a direction in law saying you to follow the All India consumer price index.
Yes.
Because it's outside the jurisdiction of the tribunal, outside the jurisdiction of the Union of India. That is why it's
Even this court.
no. This court is whether Article 142.
No, even this court.
So, Mother, the point, your Lordship asked me a very important question. Why can't you give it, mothers? Now, well, how will I give it? I'll have to borrow money. For borrowing money, I'll have to go to the Reserve Bank of India. The Reserve Bank of India will have to allow me, depending on my public debt. Then I'll have to go to the state legislature, pass an appropriation bill. Then the money can be disbursed. That's the procedure, Mother. I can't give it just like that. So, Mother, there are several aspects. Suppose, and Mother, this has happened in the past. During the COVID period, No dearness allowance was paid. In Bihar, floods take place, enormous expenditure takes place. How can the state legislature even afford to pay sometimes? This happens also in Himachal Pradesh, this happens in Uttarakhand, right? A tsunami may happen in the coastal areas. Our Manrega salaries are not paid. I have to pay them from my own pocket. There are so many issues that arise, so we have to have the fiscal space to pay this, right? Now, how can that be done by a direction of this nature? It's not possible. So when your lordships put it to me, there is a whole process that has to be followed. I can't just do it like that. Now, in the absence of that process, there can't be a direction. And actually, the whole judgment suffers from that basic error that an All India Consumer Price Index can be foisted on the state government to add it to the salary, indexed it in the way that they want.
Yeah.
Because as a constitutional issue, it's not possible to do that.
Very well. Thank you. Anyone say anything?
There's a short list of dates that I had prepared, and there's a short amount of submissions.
Yes, Mr.
Now, the first entry, your lordship may only. You had the 5th Pay Commission recommendations on 12/2/2009.
Correct.
And they recommended sanctioning 2 installments of DA. Your lordship will get that from page 97 to 99.
Yes.
Now, this recommendation was not implemented by us. We did not accept this recommendation. So, while framing ROPA, we didn't say that give DA twice a year, nor did we say that you adopt central government things. So, that's very clear. Your lordship gets that in the second entry.
Yes.
And your lordship will get that at the pages that I have mentioned.
Okay.
That ROPA did not really pick up this particular aspect.
Yes.
Now, at the first instance, when the OA was filed, it was filed, for implementing the recommendations of the Pay Commission. The OA was refused. And the OA was dismissed. Your lordship will get that judgment at page 197 to page 230 of the special legal.
Yes.
Then the matter, went back to the tribunal on a remand.
Yes.
And it is on the remand that the impugned judgment was passed on 26/7/2019.
Yes.
So I'm just handing over these dates, just for the sake of clarity.
Please.
Then, your lordship will just come to how the High Court dealt with this particular aspect. And the High Court proceeded on the basis that we had accepted the recommendation of the Pay Commission, which is a fundamental fallacy in the judgment of the High Court. If your lordship sees the reasoning from page 18.
You want us to read the High Court judgment?
Yes, volume 1.
Yes.
I'm only trying to point out that perhaps with the greatest respect, the High Court actually missed the point. Just see from page 19 onwards, paragraph 18.
Paragraph?
Paragraph 18, page 19.
Okay.
The aforesaid recommendation.
Just one.
Yes.
Yes.
In fact, if your lordship reads from page 17.
You want us to come to page 17?
Page 17 was first paragraph 17.
Yes.
The 5th Pay Commission under chapter 10 relating to allowances amongst others reported and recommended as under.
Yes.
And then your lordship comes to 10.6 at page 18. It is evident from the above that the state government sanction of installment does not follow any definite pattern. It is also clear that there are delays in payments of various installments of DA. There cannot be any differences of opinion regarding the need to avoid the delays. we are of the opinion that some extra effort, the state government should be in a position to clear the backlog of loan installment, which was sanctioned by the Government of India with effect from 1st July 2008, and then fall in line with the central government pattern of sanctioning 2 installments of DA each year. We recommend this course of action. If it is done, it will mitigate a long-standing grievance of almost all the employees within our terms. The aforesaid recommendation of the 5th Pay Commission has been accepted by the government by promulgating ROPA Rules 2009. This is factually incorrect. Because A, the ROPA rules don't speak about adopting this particular basis. Secondly, there is nothing in the ROPA rules with regard to revision twice a year. As per rules, we see existing emoluments mean aggregate of one existing basic pay, DNS pay appropriate to the basic pay, and DNS allowance appropriate to the basic pay at index average 536, 182 is equal to 100. As quoted above, the coordinate division bench in the judgment has held that the claim of the employee serving under the Government of West Bengal for DNS allowance is based on a legally enforceable right of all the employees serving under the Government of West Bengal up to such extent of the recommendations of the 5th Pay Commission, which has been accepted by the Government of West Bengal by virtue of the provisions of Sub-Rule 1 of Rule 12 of ROPA rules, read with paragraph 10 of the clarificatory memorandum, being number such and such, dated 23rd February 2009, on the ROPA rules by the Government of West Bengal Finance Department. Audit grant in paragraph 3 of the memorandum, bearing number 1692, dated February 23, 2009, in the matter of withdrawal of DNS allowance in revised pay structure under the ROPA rules 2009, issued by the Government of West Bengal. This observation, as stated above, has attained finality. Therefore, we have no hesitation in our mind to hold that state government employees under the ROPA rules has acquired a legally enforceable right to get DNS allowance at the rate to be fixed on the basis of All India Consumer Price Index as embedded in Rule 3C of the ROPA Rules 2009. Now, there is nothing, my lords, in the ROPA Rules of 2009, as was pointed out by my learned friend Mr. Devan, that this dynamic price index is adopted by the state under the ROPA Rules. So, this is, my lords, an error on the face of the record. The High Court proceeds on a basis which is factually incorrect. And then, my lords, your lordship sees further, in view of the decision in the coordinate bench, the employees under the West Bengal State Electricity Transmission Company are entitled to DNS allowances at the rate of the central government. The learned tribunal in the impugned judgment has struck down the relevant office orders and memorandums under which DA was paid to state government employees working in Banga Bhavan in New Delhi and youth hostel at Chennai at the rate payable to the employees of the central government, holding that the orders or memorandum discriminate, offending the doctrine of equality under Article 14 of the Constitution, bearing in mind the principles enunciated by the Honorable Apex Court in its decision on the case of Nakara, reported in such and such. We hold that the classification of the state government employees working as West Bengal and the state government employees working at Delhi and Chennai, governed by the same statutory rules, is discriminatory, sounds intelligible differences, and offends the golden doctrine of equality under Article 14 of the Constitution. Since the claim of the state government employees of DNS allowance at the rate to be calculated on the basis of All India Consumer Price Index has fructified into a legally enforceable statutory right, cite AIR 1961-86, cited by the learned Advocate General, pertaining to payment of DNS allowance to workmen whose conditions and services are contractual in nature under private individuals or organizations are not applicable to the facts of the case on hand. Similarly, in view of the factual and legal scenario, the above decisions in the state of Tamil Nadu are not applicable. And then in paragraph 23 and 24, which was placed by my learned friend Mr. Devan, which I don't need to read, my lords, it is held, their lordships have come to the conclusion that grant of DA on the basis of this particular rate would be a fundamental right, with which, my lords, even the other side has said that it does not really press the point, so I don't need to read. The fundamental fallacy in the judgment of the High Court is that it assumes that the ROPA rules actually incorporate a dynamic consumer price index, which is totally wrong. In fact, Manoj, that is apparent from the definition of the word existing emolument, which freezes a particular base at the year 2006, which is then adopted and used as a base. It doesn't say that the price index will be the same. I asked myself another question, and I'll just read two passages from the tribunals. The tribunal, on the one hand, comes to an express conclusion that you can't import central government rates to the state government for the purposes of BNSR. And it says that there is no right in this regard to do that. Now I ask myself this question, that if this is not static and if it is dynamic, what would be the ultimate end result? The ultimate end result is the same. Because if you adopt that particular rate, that is the rate which the central government adopts, and that will be the end result. So there are two points of contentious aspects in the order of the tribunal which I want to point out. If we were told that you fix the norms, etc. The norms, etc. have already been fixed by us by virtue of notification. But it doesn't stop there. It says it uses the expression time to time, and it says twice a year, which are both practices followed by the central government. And that is where the error has crept in the judgment of the tribunal.
How has the second judge dealt with second judge?
It's similar.
Similar.
There.
Has he given any other reasoning?
No.
No other reasoning is given?
I can place the findings.
No, we only. Whether any reasoning has been.
On this aspect, there is no reason.
There is no reason. Okay.
In fact, Manoj, if your lordship sees.
No, we have understood your point.
At page 39 and 40 is Manoj the finding.
According to you.
Of the
to you.
Lordship.
In view of what Mr. Diwan has argued, Mr. Simpleton, according to you, in view of 3C Roman 3, which is static in nature, there is error in the finding that para 33 of the tribunal as also the High Court.
Lordship.
So therefore, there no mandamus could have been issued, more so by the tribunal.
Lordship. And your lordship will just see those two particular findings of the tribunal. The use of the expression time to time, from time to time, which your lordship will get at page.
Yes.
Page 484, paragraph 33.
Page
484, paragraph 33. This is where the rub comes.
484.
Page 484, that's in volume 2.
Yes. Para 33.
Para 33. We have already observed.
Just now.
Sorry.
Yes.
We have already observed that there is no mandate under the statutory rules, viz. ROPA Rules 2009, or in the administrative directions issued by the central government in the form of Memorandum Number 1691-F, dated 23rd February 2009, and Memorandum Number 1692-F, dated February 23, 2009, that DA will be paid to the employees by the state government at a rate from the date as paid by the central government to its employees. In the absence of any mandate under the statutory rules or the administrative direction, we are unable to hold that the state government employees are entitled to get DA at a rate payable to its employees by the central government. However, from the discussion made by us here and above, we can hold without hesitation that state government employees are entitled to get DA on the basic pay at the rate to be calculated on the basis of AICPI number published from time to time. By taking the base year 1982, that is 1982 is equal to 100. Now, this is one of the first difficulty. How do you incorporate from time to time, which means Malaz a dynamic index, which is not part of the ROPA rules at all. And further, it is the bounden duty of the state government to evolve norms, principles for payment of DA to its employees by calculating.
Anyone else this time?
Then, well, my written note,
You can keep it.
I've just, yes. It just encapsulates all the points.
No problem, we'll go through. Is there, Mr. Diwan is not there, Mr. MD is there. Mr. Gopal Subramanian, we tell you. We don't shy away from saying so we want to help. You are government employees, you serve the government, you will have to tell us how can we help. We'll continue there.
And what we have understood is that having held that court cannot issue a mandamus for grant of central DA. Now the court has granted it, according to them, court has granted the same by applying ACPI.
That's correct.
That is the crux. That is what their submission is.
Correct.
Having said that, it can't do, they have done it, the High Court and the tribunal, by applying ACPI, that is the.
That's the point.
According to us, what the High Court and the Tribunal.
And according to you and the High Court, ACPI, the application of this, what is this, ACPI,
Yes.
AICP, is inbuilt in 3C.
Built the rule.
Inbuilt in 3. That is your case.
Yes, and it is from time.
Court has not applied any alien formula. It is inbuilt in 3C3. That is what your case.
Yes.
Their case is the rule makes it static. We say
We can't be more clearer than this.
correct.
As of now, the task is not as simple.
We are testing us whether we have understood.
Absolutely, these are very fair questions to be answered.
Well, there's only one aspect I want to say. Any order of your lordships in this context is going to impact all states in India.
All states
Kindly have.
who have not chosen central DA.
I'm sorry.
All states who have not chosen central DA.
And therefore,
Not all.
modification, they will be deeply interested in this issue. That's what I'm saying. Maybe your lordships might think in terms of actually hearing them, because this impacts them directly.
We certainly consider.
It's something very important.
We'll certainly consider it.
Yes, sir.
Mr. Sibbal, it's a very valuable suggestion.
That's right.
We'll consider.
Yes.
Please do.
We'll ponder over it.
Yes, sir.
Definitely tomorrow
Because
we are.
the federal structure is at stake.
In fact, no, in the morning only we said, yesterday we said, it's going to have all India plan.
Exactly. It's not just a West Bengal matter.
Correct.
Your every case is pan India, Mr. Sibbal.
Well, we are confined to our own state rules anyway.
Except that I don't have any impact pan India.
No, can't say that.
I wish I had.
Yes, one more aspect, because if I may just point out.
Confined to the
In a-
state rules.
In our application, which we had made, we have given certain figures, because the fiscal aspect is something which your lordships have stressed. As to the extent of burden it will,
36,000 crore.
yes, and the extent of burden that will fall on us. But your lordship may just bear in mind page 5 onwards of that application, because we've given figures.
Mr. Singhvi, in
Well,
fact,
many
has said
ancillary
this,
questions
like,
would come if there is this.
1 minute, sir, please, we have not finished. We have not called upon you, sir.
Oh, that's
But nonetheless, we have told you the difficulty which is there. If you read the code by now. So therefore, we can't be more candid than this.
that's
We want to help you. Tell us how best we can help you.
that's true. We have also tried to put that assist your lordship at that exchange.
Obliged.
Page 4 onwards of my application, I gave all those figures.
Tomorrow. Sure.
Yes. to give this.
It's no problem. No problem.